sweetie.
Hi, Auntie. How are you?
I'm good. How are you doing?
Fine, thanks. But we have an issue brewing at my condo between two neighbors. I remembered you're on your condo's board. Could I ask for your help?
Sure. Tell me about the problem.
Well, here's what happened. One neighbor is accusing the other of breaking the house rules, and it's getting messy. Our board is getting involved, so we hope this can be resolved fast and without drama.
Uh-oh, I'm sorry to hear that. There are ways to resolve disagreements. I'm not an expert, but I'm happy to share what I know. The philosophy of condo law is based on self-governance and self-enforcement by the owners with little government intervention. So, when disputes arise, the parties should first discuss the issues calmly, focusing on the facts. Simple misunderstandings can often be resolved quickly if each party openly communicates. And since these are your neighbors, it's important to resolve these disputes instead of letting them fester. If that doesn't work, there are several dispute resolution options available. They are mediation, arbitration, and litigation. Mediation is an informal, inexpensive, confidential way to resolve disputes. In mediation, the mediator acts as a neutral third party. There are two types of mediation, facilitative and evaluative. In facilitative mediation, the mediator facilitates a discussion between the parties to help them understand each other's point of view and work out a solution. In evaluative mediation, the mediators are often attorneys or retired judges who are familiar with Hawaii condo law. This means they can evaluate and provide an assessment of each party's position. Just remember, the mediator does not decide who is right or wrong, but may provide insight as to who is more likely to prevail if the dispute goes to court. If the parties are willing to participate and want to reach a resolution, mediation will usually be a success.
Oh, I didn't know that. But wait, aren't mediation and arbitration the same thing?
No, they're not. There are similarities, but big differences too. Like mediation, arbitration is a way to resolve disputes outside of court. The arbitrator, like the mediator, is an impartial third party. Unlike mediation, in an arbitration, the parties present their evidence to the arbitrator who reviews it and issues a decision. This decision can be binding or non-binding on the parties. With voluntary binding arbitration, the parties are bound by the arbitrator's decision and must first participate in evaluative mediation. The costs for mediation and voluntary binding arbitration are subsidized for condo associations registered with the Real Estate Commission. The last alternatives for resolving a dispute are regular arbitration or civil litigation. These are usually the costliest, most time-consuming, and most contentious options. Going to court is expensive, and it sometimes takes years for cases to go to trial. Lawyers are often hired, and a judge or jury will make the final decision. The parties involved should think very carefully about choosing these methods because their adversarial nature can result in continued conflict between the parties. The Real Estate Branch website has helpful dispute resolution info for owners and boards. Remember, many disputes can be resolved by discussing the issues with a cool head rather than letting them get worse.
Definitely. I visited the Real Estate Branch website last week and learned a lot. Now I've learned even more. Auntie, thank you so much. I really appreciate it.
Of course, I'm always happy to help.
Take care, Auntie. Bye now.
Anytime. Bye, sweetie.